Have you read about labor codes recently finalized by the central government?
CPC क्यों ऑर्डर एंड सेक्शन में डिवाइड किया गया? क्या ऑब्जेक्ट था कि उसको ऑर्डर और सेक्शन में डिवाइड कर दे?
Do you think that is intellectual property theft or that is my fundamental right to express my views according to my standards?
What is Article 13 of the Constitution of India and how it reflects upon the customs?
May I come in,
आ
sir?
जाइए शिल्पा.
Good morning, sir.
Good morning. Have your seat.
Thank you, sir.
Comfortable? Introduce yourself briefly.
So, my name is Shilpa Rani. I am from Madhubani, Bihar. I did my BA LLB from National Law University, Ranchi in 2019, and since then I have been preparing for judicial services. This is my second interview with Bihar Judicial Services.
Very good. So you are from Madhubani.
Yes,
Madhubani is part of which division of Bihar administration?
it's part of Darbhanga.
Darbhanga division.
Yes.
And how many other districts are there in Darbhanga division?
Sir, I am not.
How many divisions are there in Bihar?
So, there are 9 divisions.
Okay. Can you name them?
Division exactly, I'll get confused with the districts. So,
How many districts are there?
so there are 38 districts.
And how many police districts are there?
I'm sorry. sir.
In which law there is a mention of police district? If there is a police district, there must be some legal provision about it.
Sorry, sir. I will have to read on that police district.
Okay. Generally, police workers don't have the right to form union. Are you aware?
No, sir.
Police
I'm not.
workers, police personnel don't have the right to be part of a union, labor union or trade union. But Bihar is the only state having a union of police workers. Under which provision?
I'm sorry, but I wasn't aware of this.
Okay, you are not aware.
I'll read on that.
Fine. Have you read about labor codes recently finalized by the central government?
No, sir.
No. In your BLLB course, you have studied economics as well,
Yes, sir.
micro and macroeconomics.
Yes, sir.
What's exactly the difference between micro and macroeconomics?
Sir, I cannot recall right now. Like, it was in initial
Okay,
years.
anything you remember which you have studied in economics?
Sir,
Are you comfortable in English or we can use Hindi mixed language also?
sir, I am comfortable with either, and I have opted for the English medium. So, English is fine with me. But regarding economics,
Nothing you remember?
so I remember making some graphs, but the content I cannot recall. I'm
Okay, fine.
sorry.
Okay, never mind. Can you tell us whether there is a woman judge in Patna High Court?
So currently, in my knowledge, there is no woman judge in Patna High Court.
And you're sure about it?
So the last time I read, there were no judge in Patna High Court.
Okay, briefly tell me the hierarchy of local courts, hierarchy of judicial officers in local courts.
And locally, there is session and session judge, district and session judge. Below him, there is additional district and session judge. Below him, there were provisions for assistant, but that has been removed now. And thereafter, there is a chief judicial magistrate, and then judicial magistrate first class. And if there is provision for judicial magistrate second class, then
So after you are selected, you'll be posted at which rank?
so in Bihar, there is still provision for judicial magistrate second class. But what I have read on the bios, initially they are called probationary munsifs, and then it is judicial magistrate second class.
So what is the jurisdiction of Munsif?
I'll have to read there on that. I was just aware that they are called.
Jurisdiction is defined on which parameters?
So there are 3 parameters to define jurisdiction. The first one is subject matter, second is pecuniary, and the third is territorial.
Okay. So you are not aware what is the territorial jurisdiction of a Munsif or a CJM?
I think the district in which they are posted is there.
Okay, never mind. Thank you, Shilpa.
Shilpa, what is your favorite subject?
I think law of evidence is
What is the difference between evidence and proof?
the evidence are the medium through which we can prove anything, and proof is what court admit.
Evidence cannot admit the court.
The proof is once we prove anything through the medium of evidence, then it becomes a proof.
For example, you can explain it.
May I have some 2 seconds to think. Sir, thank you, sir. I believe that if I'm bringing any document then the document would be the medium, would be the evidence, but the ownership would be proved. So I think the owners, sir, I'm a bit confused. I'll read on
Okay,
that.
no problem. Shilpa, your optional subject is the constitutional law and administrative law. First of all, you tell me what is the judicial review, judicial activism, and judicial overreach, with one specific examples.
So if there is gap, there is a gap in laws, or there is no law, and then judiciary made some law, like in Visakha case, then it is judicial activism. And if law is made by the parliament which somehow violates the constitution or the parent act under which it has been made by the executive, then Supreme Court judicially review that law to see that whether constitutional provision has been violated or not. And if there is law and then judiciary goes beyond what legislature says and then imposes its own, then it's called judicial overreach.
Any example in the context of the judicial overreach where Supreme Court act not according to the constitution and develop a new concept like a judicial overreach?
So regarding judicial overreach, I cannot recall any example.
Any example? 99th constitutional amendment, what is?
99. So it was it introduced the provision for National Judicial Appointment Committee.
Which was declared constitutional in year 2016.
Yes, it was declared
The
unconstitutional.
Supreme Court act beyond the constitution.
I would not say that it acted beyond the constitution, because separation of power is one of the feature of our constitution, and that forms the part of basic structure. So in my opinion, in my view, that is not a judicial overreach.
ओके, अब मेरे को एक सवाल और बताइए कि पायस जो ओब्लिगेशन है अंडर द हिंदू लॉ, ये क्या है और क्या प्रेजेंट टाइम में पायस ओब्लिगेशन अप्लीकेबल है या नहीं?
फिर
इन हिंदी में पवित्र दायित्व का सिद्धांत।
सर मेरे ख्याल से ये जो भी प्रॉपर्टी इनहेरिट करता है अपने फादर, नॉट प्रॉपर्टी इनहेरिट, जो भी उसके पिता के ऑब्लिगेशंस हैं वो उनके बच्चों को फुलफिल करना होता है। लेकिन अभी ये नहीं, अभी ये लॉ के अंदर नहीं है मेंटेन।
मतलब अब ऐसा नहीं है, पिता अगर मर गया तो बच्चे का कोई रिस्पॉन्सिबिलिटी नहीं है कि पिता के डेब्ट को वो चुकाए, ऐसा कोई लायबिलिटी नहीं है।
सर जितना वो इनहेरिट करता है उतना उसका ऑब्लिगेशन बनता है, लेकिन ये जो पायस ऑब्लिगेशन था कि जो भी उनका ऋण होगा वो चुकाएगा, ये अब उतना स्ट्रिक्टली फॉलो नहीं होता है।
मैं ये कह रहा हूँ कोडिफाइड लॉ में क्या अब है या नहीं, बस इतना हमको बता दीजिए। कहीं पर कोई प्रोविजन है हिंदू लॉ में?
सर आई बिलीव हिंदू लॉ में इस रिगार्डिंग कोई नहीं है, बट आई रीड ऑन दैट।
चलिए एक लास्ट क्वेश्चन मैं आपसे पूछता हूँ और आप हमको बताइए, सीपीसी क्यों ऑर्डर एंड सेक्शन में डिवाइड किया गया? क्या ऑब्जेक्ट था कि उसको ऑर्डर और सेक्शन में डिवाइड कर दें?
सर सेक्शंस सब्सटेंटिव बातें करते हैं, सब्सटेंटिव लॉ प्रोवाइड करते हैं कि एक्चुअली क्या होगा, लेकिन जो एक डिटेल्ड प्रोसीजर है वो हमारे ऑर्डर्स में दिया गया
ये तो ठीक है, लेकिन डिवाइड क्यों किया गया? हम प्रोसीजर के लिए अलग पार्ट का उसी के साथ सेक्शन के साथ प्रोसीजर जोड़ देते। जैसे सीआरपीसी में हमने कोई डिवीजन नहीं किया, तो हमने सीपीसी में ऐसा क्यों कर दिया?
सर सीआरपीसी को कॉम्प्लीमेंट करने के लिए आईपीसी है, एंड सीपीसी का डिवीजन अगर एम्बिग्विटी क्रिएट होती अगर सेक्शन और ऑर्डर्स एक साथ होते हैं। और दूसरा मुझे एग्जैक्टली आई कैन नॉट रिकॉल, लेकिन अमेंडमेंट को लेके भी इजी है कि स्टेज अमेंडमेंट्स ऑर्डर में अमेंडमेंट्स किए जा सकते हैं इजीली। तो अगर कोई प्रोसीजर है जो भी प्रिस्क्राइब किया गया है तो उसके अमेंडमेंट को इजीली करने के लिए ये डिवीजन किया गया है।
सर
शिल्पा जी मुझे बताइए, क्रिमिनल प्रोसीजर कोड में द section 482 of CRPC, which is now 528 of BNSS, it talks about the inherent powers of the High Court. Can you tell me, has the legislature conferred the inherent powers, or did they per se exist in the High Court?
So the inherent power per se exist with the High Court. They are the power that power belong to them by virtue of being a court, and the legislature does not prescribe that. In fact, it limits that the power would be exercised within the limit of doing complete justice. So inherent power is very wide power that is per se with the High Court.
So the legislature has restricted the inherent powers of the High Court, or the legislature has saved the inherent powers of the High Court?
So I would say it has restricted the ways in which it should be exercised. Otherwise, the power is very wide. So in case where there is already a remedy, so one should not approach High Court for under this 482, since there is already an existing remedy. So legislature, in my opinion, has restricted it.
And why only the High Court? When the purpose of each and every court is to do complete justice, why has the legislature declared that only the High Court has inherent powers? Do the Court of Judicial Magistrates have inherent powers?
No, sir. No, sir.
Under CRPC, they do not have inherent powers. What about the Supreme Court? Why have we left the Supreme Court out of the structure?
So Supreme Court, there is constitutional provision for the inherent power of Supreme Court. So I think it's
But there is a
Article 1.
constitutional provision for the High Court also.
It does not provide for the inherent power of High Court. The inherent power of Supreme Court has been specifically provided under the Constitution.
May I ask where?
I think it's Article 142.
Okay. Under Order 2, Rule 2 of the Civil Procedure Code, if there is a relief that you have not claimed and you take the permission of the court, a subsequent suit is not barred. What about a subsequent claim?
I think Order 2, Rule 2 talks about the relief, but Order 2, Rule 1 talks about the claim. So if one does not include all the claim, then he is barred. Also, in this respect, there is a concept of constructive res judicata, that if a person does not include all his claim in a suit, then he is later barred from raising that.
So in effect, there is no difference between constructive res judicata and Order 2, Rule 2.
So there is difference. Constructive res judicata is applicable to both the parties and to entire suit, but Order 2, Rule 2 is regarding relief only, so it bars plaintiff only.
So claim is not included in Order 2, Rule 2.
So I believe claim is not included. It talks about the remedies only, but I'll wait on that.
Okay. Can a woman be declared as a karta, or can she only be a manager of a Hindu undivided family?
So I'll have to read on that. I'm not aware of the position of a woman regarding being karta.
Okay. Are you aware of the specific relief act? I see that you've opted it also.
Yes, sir.
I wanted to know if there is an intellectual property and somebody is in possession of it. Does the specific relief act talk about the immediate return of this intellectual property?
So the property is intellectual property.
Yes.
Sir, I'll have to read on that.
My last question, how do you relate to intellectual property rights and the freedom of speech and expression? If my expression of a particular aspect coincides with somebody else, do you think that is intellectual property theft, or that is my fundamental right to express my views according to my standards?
I beg your pardon. I could not understand the question.
I'm saying, what is the relation between intellectual property rights and the freedom of speech and expression? If I express my opinions and somebody else has the same opinion on that aspect, does it coincide? Is it intellectual property theft or violation of the intellectual property of that person, or it is my fundamental right to speech and expression?
If I'm expressing someone else's opinion, then it becomes violation when I express it as my own. But if I am giving due regard to the person to whom it belongs, then it is my rightful exercise of freedom of speech and expression and not the violation of intellectual property.
Thank you, sir.
Shilpa, let's talk a little bit about history. Are you aware of history of Bihar during medieval period? Anything you read about it?
During medieval period, so I have read out, I cannot recall the kingdom in medieval period.
You like kavita part or poem recitation? Which
I
kind
like
of
reading.
Hmm?
I like reading poems.
right? Which kind of poems you have read so far? English, Hindi, Mathili, what?
So Hindi and Mathili. especially Vidyapati.
Yeah, I was referring to Vidyapati ji only. So during which rule he was living, he was creating his literature. He has repeatedly, frequently shown his gratitude to the ruler in which court he was serving. So which ruler he was referring to frequently?
I'll have to read on that.
Have you heard about any dynasty in northern Bihar which was called Karnat dynasty? And was it having any connection with Karnataka state?
No, sir. I'll have to read on that. I'm not aware of.
Okay.
this.
So you know that Vidyapati ji wrote poems, many kinds of literature in Mathili. But more importantly, he was actually poet of Bangla literature. Are you aware?
No, sir. I thought he was writing Mathili only. Mathili poems and songs.
Initially, he was writing in Bangla, but later on, Mathili. And are you aware he also composed some product in Bhojpuri language also?
Yes, sir. That I have heard that he composed some in Bhojpuri as well.
Have you read something about it?
No, sir.
Okay. Can you recite any of the stanza of Vidyapati ji?
So the one I have heard since my childhood is like I have heard many. They are mainly in prayer for Shivji and whom we call Mahadev, and the one I can recall right now is,
Gone.
he was looking for Shivji because it's a tale that he came to him as a servant, and he named himself Ugna. So the poem is Ugna re muhe katay gila Shiv kidahu bhelai. Because Shivji has barred him from saying to anyone that he is Mahadev, but he told his wife that he
What is your mother tongue? I understand the meaning. What is your mother tongue?
Mathili.
But your pronunciation is not very comfortable in Mathil. Diction is not very clear. Do you really talk to your parents in Mathili language?
Yes, sir. And
If you're posted somewhere in North Bihar, sometimes the advocates would be arguing their cases in Mathili as well. They use local tongue, Bhojpuri, Mathili, Angika.
so Mathili is my mother tongue. Like on daily basis, I talk to my parents, my relatives in Mathili only, and I speak that very fast. So yes, I've been speaking Mathili since birth in my family.
So let's say there are certain social customs only found in Mathil region.
Yes, sir. There are.
And as a judicial officer, you have to consider people's faith in that custom. And as a trained judicial officer, you are also having your loyalty to the constitutional law or statutory law. If there is any conflict between the provisions of customary law and statutory law, what kind of opinion you will form about it?
I believe that in case of conflict, the constitutional law should be followed. But the parallel problem is talking to people regarding their custom being unjust. So I will try to follow the constitutional provisions at the same time, awareing people that how it is unjust.
What is Article 13 of the Constitution of India and how it reflects upon the customs?
Article 13 provides that any pre-constitutional law or post-constitutional law, if they are in conflict or in contravention with the provision of Part 3, that is the fundamental rights, then they are void to that extent. And also it defines law, and it includes custom within the meaning of law.
So you know that in Hindu Marriage Act also, a Hindu person, male or female, cannot marry two persons at the same time. It's illegal.
Yes.
The second marriage is considered void. But you come across many Hindu families where you see two wives, maybe three wives, living wives, and there is a social custom.
So in my life, I haven't came across any son marriage.
I'll tell you, Mr. Dharmendra, the superhero of Hindi cinema, is having two living wives.
I believe he is divorced from his first wife,
No.
Prabhat. I wasn't aware of that. I have heard of two wives, but that was prior to my grandmother used to tell stories. So they were those characters. But in my life, I haven't come across any person who having two wives.
So whether the second marriage becomes void ipso facto or it is declared void when moved by the first representatives of first wife.
Sir, if there is a second marriage while first wife is living and it has not been annulled, So second marriage is wide ipso facto.
Nice talking to you, Shilpa. Your interview is over. You may go now.
Thank you, sir. Thank you, sir.
Have you seen Shilpa? Your interview is on 22nd of November and this is 27th. Almost 25 days are left with you. After having this experience, you have also appeared in interview last year. So you have that experience also. How do you reflect? What are the things you believe are going in the right direction and where do you think you should have a better focus or maybe reorientation or presentation?
There, I forgot many things, like the Vidyapati poem. Like I was listening to that in morning and that went like completely out of my mind. So and try not to be nervous. I was quite nervous and I tried not to reflect that, but I forgot things. And that family law is a weak point. So family law and so a bit about the history of Bihar I'm missing, and
Economics also you are missing.
economics I'm completely missing. I didn't expect the questions from economics at all.
Because you studied in your BLLB integrated course, maybe some teacher from law college comes in the interview board. So, but that's not necessary that they'll be asking you economics question, but general knowledge should be there, at least.
Like all the subjects in LLB,
Judicial
BLLB.
officer has to be aware about the entire context. When a client comes, a person seeking justice comes, you have to look at his economic condition, his social condition, maybe political condition as well. Okay, fine. See, overall your performance is good in the sense that you are articulating your views and your language was good. You are having good understanding of the legal parlance. That part is good. And the point where we felt that you should, the very first thing is that in spite of all the knowledge which you have already tested in PT and mains, etc., in your previous interview overall, and in spite of all the knowledge you'll be gaining in next 25 days, there will still be left some part. Law is very vast subject. So there will be still left with some part where you will not be very comfortable. And they know that. After practicing law for 20-30 years, nobody can claim that he is comfortable over all the dimensions of law. The CJI cannot claim, isn't it? Such a vast subject. There are so many living laws in India, more than 4,000 acts are still in force. So be comfortable that if you don't know, don't feel yourself to be culprit. Because at this stage, you are not expected to know everything. You are expected to articulate what you know. As judicial officer, you are given enough time or you can take enough time to study the different situations of the arguments and the law and the condition. And this is why the judicial process is so lengthy and time consuming. So what the central point is that be aware that nobody can be omniscient in law particularly. If you don't know, that hardly matters. But keep your confidence level intact. You have been thoroughly polite and believe that you are too polite. You should be a little more assertive. If you are nervous, you'll be subdued. It looks subdued, rather not only politeness. So you should be polite but not subdued. You should be more assertive. Once you have decided that you'll be assertive, you'll be expressing your opinion freely and fearlessly, you'll be able to articulate it well. And that if that attitude or articulation improves, your flow of communication would also improve. There were some hiccups while you were speaking between. There was some slow pace of expression because of that continuous nervousness and continuous sense of some kind of inherent inhibitions kind of thing. That's not very good. See, a woman in Indian society, particularly society of Bihar, the socio-cultural milieu of Bihar, is not very conducive for conditioning of women's mind. You have to prove that you are free from that restrictive conditioning of female mind, and that you have exercised that right to freedom of speech or expression in true sense. Okay, so that's the central part of our understanding and feedback. Apart from that, because this exercise is a kind of also exploration of certain domains of knowledge. So whichever questions have been asked to you, and whichever answers you have formulated yourself, reflect upon that also. For example, in that administrative law versus constitutional law question, judicial activism, judicial overreach, etc., the phrases are so frequently used that those persons who are not trained in law are also a little bit aware about it. And because you are trained in law from national law and state, so you are expected to be more precise in your expressions about these very popular phrases. So not only these phrases, have a set of judicial jargon in every important paper, constitutional law, criminal law, torts, contracts, etc. In every paper, you can pick up some 20-30 typical terms and concepts and develop very clarity about it. But if there is a point blank question, you'll be giving a point blank answer in a very objective fashion, precision also, in a more precise manner, to the point answer. That will improve your image as a student. Overall, the impression we have got that you are a sincere student, you are over cautious in expressing. This is why I am suggesting that the first line of feedback is be more assertive. And in spite of being so cautious, if there is some inaccuracy in expression, that is not adding up to your favor. Getting the point? So just two things. Your dress, I hope, would be wearing not this kind of
No,
dress.
sir. It's a sari. It's cream color sari. I was afraid that it might get like spoiled kind of. So
Fine. It's still 25 days apart. So work on these two things. Keep on brushing your knowledge and be more assertive. Feel at ease. See, the philosophical part is that if you'll be very much expectant about positive result, it will produce and it will build pressure in you. So adhere to that in philosophy contained in Gita. Don't expect results. Ma phaleshu kadachan. मत करो फल की चिंता करने से ही साइकोलॉजिकल स्ट्रेस बनता है. ठीक है. फोकस ओनली द फंक्शन यू आर इन हैंड, योर वर्क. इंटरव्यू देना है, पिछले साल से अच्छा परफॉर्म करना. पिछले साल कितने मार्क्स है?
33
आउट ऑफ
100. That was like
33?
disqualified in interview. 35 is the qualifying mark.
और वो उसका कारण सिर्फ ये है कि आप नर्वस उस वक्त भी रही होंगी, इससे भी ज़्यादा. तो आपके पास खुशी की बात ये है कि इस बार मार्क्स तो कम से कम डबल आएंगे ही आपके मिनिमम. और अगर आप इन दो चीज़ों पे सिर्फ काम करें, अपने अंदर के फिलोसफिकल कंस्ट्रक्ट को ठीक कर लें, बहुत रिजल्ट ओरिएंटेड ना सोचा करें. रिजल्ट सोचने से नहीं आता लाइफ में. ये लाइफ फिलोसफी गीता वगैरह में सोचने से रिजल्ट आता ही नहीं है. ठीक है. क्रिकेट के टर्मिनोलॉजी में कहते हैं कि छक्का मारने को सोच के जो बल्ला भाजता है उसके छक्के नहीं लगते.
आप पहले भी मैंने शायद आपको कहा था कि आपके चेहरे से प्रेशर बहुत लगता है, और ये प्रेशर आप जिस दिन कम कर देंगे वो 35 नहीं, वो क्या कहते हैं 65 हो जाएगा.
इसे इम्प्रूवमेंट मतलब मुझे अपॉर्चुनिटी मिली थी यूपी में भी इंटरव्यू देने की, तो वहाँ पे फिर मेरे मार्क्स ठीक थे, लाइक 67 आउट ऑफ 100. तो
क्योंकि आपने वो नॉलेज ठीक है. आप सबसे बहुत ज़रूरी चीज़ है जुडिशियल ऑफिसर के लिए, वो ही शुड बी और शी शुड बी अ रिस्पॉन्सिबल पर्सन. तो यू आर टॉकिंग वेरी रिस्पॉन्सिबली.
thanks.
So that's the central point. That attitude part is intact with you. The only thing is that be more assertive, feel more relaxed, और develop थोड़ी सी clarity. बोलते समय clarity अंदर आपके दिमाग में होगी, लेकिन express करते समय वो to the point आना चाहिए.
जैसे आंसर्स फ्रेम जो
हाँ, वो सोच के थोड़ा सा फ्रेम करिए. मतलब 2-4 सेकंड लग जाए तो लग जाए. सवाल सुनते समय सोचते रहिए कि अच्छा इसका मेरे को ऑब्जेक्टिव आंसर देना है, सेंट्रल पॉइंट बताना है, बीटिंग अराउंड द बुश नहीं करना है. और अगर नहीं आता हो तो पोलाइटली सॉरी भी बोलना है. सॉरी बोलने के मैं बार बार कहता हूँ कि 3 बड़े फ़ायदे हैं. एक, सॉरी बोलने का फ़ायदा ये है कि आप तत्काल प्रूव करते हैं कि यू आर इंटेलेक्चुअली ऑनेस्ट पर्सन. दूसरी चीज़ दैट यू आर हैविंग लीडरशिप क्वालिटी, कि कल को अगर आप एक डिस्ट्रिक्ट कोर्ट में हैं, आपके पास डिस्ट्रिक्ट एंड सेशन जज पूछते हैं कि या ये वाला केस आप हैंडल करना चाहेंगे मैडम, तो आप उनको कहते हैं कि नहीं, आई एम नॉट वेरी कंफर्टेबल अबाउट, सॉरी. तो इससे लगता है कि आप एक अच्छी टीम प्लेयर बन सकती हैं. वर्क एलोकेशन में आप कोऑपरेट करेंगे। ऐसा नहीं कि ग्रैब करती जाएंगी सारी चीज़ें, जो आता है वो भी, जो नहीं आता है वो भी। दैट्स सेकंड थिंग। तो वो बड़ा फेवरेबली वो देखते हैं इसको कि ये आदमी हायरार्की में अच्छा फिट बैठेगा। और तीसरी चीज़ ये है कि सॉरी बोलने का एक प्रूफ ये भी है कि यू आर नॉट एन ईगोटिस्ट पर्सन। सॉरी बोलने के लिए आदमी को हम्बल होना पड़ता है, पोलाइटनेस काफ़ी नहीं है, और पर्सन शुड बी हम्बल फ्रॉम विद इन। और वो ह्यूमिलिटी बहुत ज़रूरी है डेमोक्रेटिक सेटअप में काम करने के लिए। नहीं तो बहुत सारे जजेस बड़े एरोगेंट होते हैं, दुर्वासा ऋषि की तरह। तो दुर्वासा ऋषि टाइप का जज तो नहीं चाहिए ना। तो ये 3 बड़े फ़ायदे हैं, इसलिए 3-4 बार अगर सॉरी बोलने का मौका मिले तो आप बल्कि look forward to those opportunities where you can say sorry so as to prove these 3 attributes in your personality.
एक्चुअली होता है ना, अगर नहीं आता है तो फिर नेक्स्ट क्वेश्चन में भी थोड़ा-सा हो जाता है कि इसका तो नहीं जवाब दिया था, इसका तो देना चाहिए।
नहीं, देखिए वो इतने बुजुर्ग लोग होते हैं कि आपके इग्नोरेंस को लेकर आपके बारे में कोई ओपिनियन नहीं बनाते। उनको पता है कि बच्चा अभी सीख रहा है, जितना जानता है ये काफ़ी है। एटीट्यूड पे ज़्यादा ध्यान देते हैं।
It's not a test only of your knowledge, of your diligence also. That's very important.
ठीक है? तो ज़्यादा परेशान नहीं होना है, 2-3 चीज़ों पे काम करिए, बहुत अच्छे मार्क्स आए, हो जाएगा इस बार। डुवेल विद्यापति के बारे में थोड़ा सा सोशियो कल्चरल बैकग्राउंड पढ़ लेना चाहिए। अगर आप किसी पोएट को इतना पसंद करती हैं कि रिसाइट करती हैं रोज़ या पढ़ती हैं रोज़, तो ज़रूर क्यूरियोसिटी होती होगी ना कि भाई किस ज़माने में रहते थे, कहाँ रहते थे, माँ बाप का नाम क्या था, कैसा बचपन था, मतलब एक इंटरेस्ट होता है। तो थोड़ा सा पढ़ लीजिए उनके बारे में। ओके, ऑल द बेस्ट। एनीथिंग लेफ्ट?
सर 2 क्वेश्चंस हैं।
हाँ,
तो पहला जो वो पूछते हैं ना, व्हाई डू यू वांट टू बी अ जज? तो लाइक उसका समझ नहीं आता एप्रोप्रिएट क्या दूँ? क्योंकि हाँ, अच्छी कैरियर अपॉर्चुनिटी है, आप सोसाइटी को भी सर्व कर सकते हो, लेकिन एक एप्ट
देखिए
क्या
ये
होना चाहिए?
मैंने इकोनॉमिक्स इसलिए पूछा कि थोड़ा बहुत पढ़ाया जाता है। हर आदमी सोशल एनिमल है, और ये सोशलॉजी में पढ़ाया जाता है, हर आदमी एक इकोनॉमिक एनिमल भी है। मतलब उसको भूख लगती है, क्या करें, नेचुरली लग जाती है। अब भूख मिटाने के लिए खाना चाहिए, खाना खरीदने के लिए पैसे चाहिए, उसको सर्दी लगती है, गर्मी लगती है, कपड़े चाहिए। तो देयर आर सर्टेन इसेंशियल बेसिक नीड्स ऑफ ह्यूमन बीइंग फॉर विच वी नीड इकोनॉमिक रिसोर्सेज। वो चाहे एंसेस्ट्रल प्रॉपर्टी से मिले या हम कमाएं। अगर एंसेस्ट्रल प्रॉपर्टी है किसी की तब तो ठीक है, ना कमाएं, लेकिन अगर नहीं है तो कमाना पड़ेगा। तो हम चाहते हैं कि कुछ ऐसा काम प्रोडक्टिव करें जिससे हमारा एक रेगुलर फ्लो ऑफ इनकम बने। लेकिन ये बात पहले नहीं बतानी है। हम एक सोसाइटी में एक रिस्पेक्टफुल लाइफ चाहते हैं, बिकॉज वी आर सोशल एनिमल। सोशल एनिमल का मतलब ये है कि हम चाहते हैं कि सोशल हायरार्की में एक इज्जत की ज़िंदगी, डिग्निफाइड लाइफ, आर्टिकल 21 में सबका मूल अधिकार है, नेचुरल राइट है वो। तो वो डिग्निटी एक जॉब से भी आती है। और तीसरी चीज़ ये है कि हम चाहते हैं कि हमारी जो सोशल ऑब्लिगेशंस हैं, जो सर कह रहे थे पायस डेट्स, कि हमारे पितृ ऋण है, गुरु ऋण है, समाज के प्रति ऋण है, तो हम फैमिली के प्रति रिस्पॉन्सिबिलिटी है, हमारी लार्जर सोसाइटी के प्रति रिस्पॉन्सिबिलिटी। हम चाहते हैं कि उसको हम कंट्रीब्यूट करें, उससे हमें इनर सेटिस्फैक्शन मिलता है, इसको कहते हैं जॉब सेटिस्फैक्शन। ऑर्डर इसको रिवर्स करके बताना ज़्यादा अच्छा रहता है।
पहले
हम इकोनॉमिक्स में यही बताया जाता है कि पैसे से हम बहुत जल्दी सैटिएट हो जाते हैं। जब तक पैसा नहीं है तब तक बहुत इंटेंस अर्ज होता है कि काश पैसा होता। कुछ पैसे हो जाते हैं, अगले 10-20 साल के फ्यूचर नीड्स को सिक्योर करने वाले सफिशिएंट हो जाता है, तो हम कहते हैं चलो ठीक है। लेकिन वो जो सोशल सेटिस्फैक्शन वाला चीज़ है, वो इनसैटिएबल अर्ज होता है, उसका कोई अंत ही नहीं है।
वो तो पीढ़ी दर पीढ़ी भी होती है ना, लाइक आप अपने बच्चों से भी एक्सपेक्ट करते हो।
आप चूँकि आप मान लीजिए इंडिया में 140 करोड़ की सोसाइटी, आपने 140 करोड़ लोगों को हेल्प कर दिया इन वन और द अदर वे, तो आपका दिल करेगा कि नहीं अब ज़रा बांग्लादेश वालों को करें, पाकिस्तान वालों को करें, नेपाल वालों को भी करें, चाइना वालों को भी कर दें। तो एक्सपैंड होता रहता है अर्ज। तो उसी ऑर्डर में बात करें कि इट गिव्स अ immense opportunity for job satisfaction, this judicial power and responsibility. It gives you a very dignified status in society, and it gives you a respectable amount of resource to survive your economic life.
यस
That's it. इसमें कोई शर्म करने की बात नहीं।
यस सर, क्योंकि वो कैरियर अपॉर्चुनिटी बोलते हैं थोड़ी सी आ जाती है कि
नहीं, ये नहीं बोलना है पहले ही।
गोल, हर कैरियर के 3 ही गोल होते हैं। ये चाहे कोई पीएम बनना चाहता हो या कोई माइक्रोसॉफ्ट में मैनेजर बनना चाहता हो, कुछ भी करना चाहता हो, गोल 3 ही रहेंगे।
एंड सर दूसरा क्वेश्चन है कि करेंटली मतलब गैप के बाद मैंने डीयू से एलएलएम परस्यू करना स्टार्ट किया है, तो इंट्रोडक्शन में ये बोलना चाहिए कि नहीं, लाइक अगर
आप
पूछे कि
एलएलएम कर रही हैं,
यस सर,
जनरली हम यही गाइड करते हैं कि यू शुड नेवर कंसील एनी फैक्ट। कल को जुडिशियल ऑफिसर आप बनेंगी तो ये ओथ में आप लोगों से कहलवाएंगी, वकील से भी कहलवाएंगी वकालतनामा में। तो सवाल ये है कि इफ़ यू आर परसुइंग एलएलएम, डोंट कंसील दिस फैक्ट। इंट्रोडक्शन में आप कह सकते हैं कि सर आफ्टर कंप्लीटिंग माई एलएलबी फ्रॉम रांची, आई एम एनरोल्ड इन कैंपस लॉ सेंटर दिल्ली यूनिवर्सिटी एंड परसुइंग एलएलएम। हाँ, लेकिन रिस्क ये है कि एलएलएम के एक आध स्पेशलाइजेशन पेपर से सवाल आएंगे, तो थोड़ा सा पढ़ के जाइए।
एक्चुअली जब फॉर्म भरा था तब नहीं किया था, अभी जैसे सेकेंड ईयर में हूँ तो फॉर्म हमने मार्च अप्रैल में ही भरा
पूछ
था।
सकते हैं ना,
तो
इंट्रोडक्शन जब आप देंगी ना
yes, sir.
तो बता सकती हैं।
क्योंकि
अभी जैसे आपने
2019 का आपका है और आपका 5 साल का हो गया, तो पूछेंगे कि आप 5 साल क्या किए, तो आपको बताना पड़ेगा ना कि हम क्या कर रहे हैं। अगर आप प्रैक्टिस बताएंगे तो प्रैक्टिस पे आप थोड़ा अपना प्रिपेयर रखिए, अगर आप एलएलएम बता रही हैं तो उस पर आप प्रिपेयर रखिए, क्योंकि 5 साल का गैप है और वे पूछेंगे ज़रूर इस पर।
हाँ, गैप की वजह से तो ये बोल सकते हैं कि मतलब लाइक एलएलएम परस्यू कर रहे हैं,
पहले ही
नेट
बता दीजिए
क्वालिफाइड
कि
है।
आफ्टर कंप्लीटिंग एलएलबी आई एम नाउ एनरोल्ड इन एलएलएम, आई एम सेकंड ईयर लॉ।
सर तो ऐसे ही है, बस मुझे सब्जेक्ट जनरल एलएलएम है बट सब्जेक्ट्स पे
हाँ, एक दो पेपर तैयार कर लीजिए।
कॉन्स्टिट्यूशनल लॉ ये स्पेशलाइजेशन रखिए जब आपको फेवरेट है तो।
नहीं सर, इन जनरल है।
जनरल है,
हाँ, वो 4-5 और सब्जेक्ट्स देते हैं इंटरनेशनल लॉ से, जो भी उसमें से पिक करने होते हैं। तो जनरली मेरा इंक्लिनेशन क्रिमिनल लॉ की तरफ ज़्यादा रहता है, क्योंकि वो मैं जुडिशरी के साथ साथ पढ़ सकती हूँ, लाइक
ठीक है,
प्रिपरेशन
तो
के
आपने
साथ।
अगर क्रिमिनल लॉ ऑप्ट किया तो बता दीजिएगा कि अगर पूछे थे तो अपनी तरफ से बताने की जरूरत नहीं है।
ऑनर्स भी क्रिमिनल लॉ में है,
सर हमारे एनएलयू रांची में ऑनर्स लेने होते थे 4th ईयर में जाके,
तो उसमें भी
तो
क्रिमिनल
क्रिमिनल ऑनर्स लिया था।
अगर वो पूछते हैं स्पेशलाइजेशन कुछ है तो बताइएगा कि हाँ क्रिमिनल लॉ में सर मेरा इंक्लिनेशन।
एंड डिजुटेशन हमारा नेक्स्ट सेम से स्टार्ट होगा, तो एक ये भी बोल सकते हैं कि नहीं अभी नहीं सोच।
नहीं, जब तक वो छेड़ते नहीं तब वो तो
अगर उन्होंने पूछा, क्योंकि एलएलएम से नेक्स्ट सवाल यही आता है कि आपका डिजुटेशन क्या है,
क्या है तो कहिए सर अभी सब्जेक्ट अलॉट नहीं हुआ है, अभी आने वाला है नेक्स्ट सेमेस्टर में।
सर ऑनेस्ट रहना है।
हाँ,
थैंक यू सो मच सर, थैंक
ओके,
यू
ऑल द
सर,
बेस्ट।
थैंक्स।